Good afternoon, and thank you for joining us today for the policy update discussing Title IX and other recent revisions to CSBA sample policies webinar. My name is Alex Zuko. I am a policy manual consultant at CSBA, and I'll be facilitating today's webinar. Before we get started, I wanted to make a few quick announcements. If at any time you have a question for presenters or a technical issue, please use the questions tab of your GoToWebinar dashboard. This is located on the side of your screen. If you don't see the webinar dashboard, it may be collapsed. Look for an orange arrow in the top right corner of your screen. Click on that arrow and it will expand the dashboard. In today's webinar, we will be discussing policy changes resulting from revisions to the federal Title IX regulations, special education policy, and infectious diseases. At this time, I would like to introduce our panel for today's discussion. Bodhi Oyele, Associate General Counsel for CSBA, Bob Turk, Assistant Executive Director, Policy and Governance Technology, CSBA, and Barbara Latham, Policy Manual Consultant, CSBA School Board President, Oak Park Unified School District. To start us off today, I'm going to turn it over to Bodhi.
Good afternoon. Never mind what Alex said. My name is Bodhi Oyele. I always say that to give myself some confidence, since I'm the only one that knows how to pronounce my last name. You're welcome to this webinar. So it's going to be, my part of the presentation will cover the federal Title IX regulations and the policy implications for California's elementary and secondary schools. It's a very extensive a piece of legislation or regulation, if you will, but we're going to try to cover some highlights of them, especially as they relate to school district policies and implementation practices. So without further ado, if I might have the next slide, please. So these Title IX regulations were issued, I believe, in May this year by the U.S. Department of Education, and they are scheduled to take effect on Friday, August the 14th. That is, unless one of the pending lawsuits in federal court put a stop to it for now. That is, if a stay is issued by one of them. We know as of today that two courts have rejected the application to have to stay the effective date of these regulations. So we're waiting still on one. If that last court issues a preliminary injunction, then these regulations might not come into effect. But I don't think we should hold our breath on that. I think we should go ahead and see if this have become effective and seek to be compliant on them. So our discussion of Title IX regulations would begin with a definition of sexual harassment for the Title IX purposes, just because the feds, the U.S. Department of Education has sort of defined sexual harassment that in a way that is not entirely consistent with how California has defined sexual harassment. The difference is, it's very important to note the difference because a different grievance procedure might apply depending on whether conduct is found to be sexual harassment under Title IX or only sexual harassment under state law. Second, we're going to address what a school or district is required to do when they receive a complaint of sexual harassment. That will be the response to allegation of sexual harassment part of this presentation. And then we will go over the grievance procedure for resolving sexual harassment allegations. For Title IX, these are very extensive, even though narrowly focused. And then if we have some time, we will talk about further obligations that schools may have. Next slide, please. So as I mentioned earlier, sexual harassment under Title IX is narrowly crafted. And so what conduct that may be sexual harassment under state law may not necessarily be sexual harassment for Title IX purposes. So school officials have to pay attention to this, because that will generally dictate what grievance procedure they must use to resolve that complaint. So for sexual harassment under Title IX, it is defined as in 3 parts. One is if a school employee, based on the basis of sex, if a school employee conditions the provision of an aid, benefit, or service of the school on an individual's participation in unwelcome sexual conduct. In other words, what you generally understand to be quid pro quo, that will be sexual harassment under Title IX. Another instance would be, still on the basis of sex, if unwelcome conduct, which might be determined by a reasonable person to be so severe, pervasive, and note the conjunctive, and objectively offensive, that conduct effectively denies a person equal access to a school's education program or activity. That also will be sexual harassment. In other words, what you used to know as hostile environment. The only difference is that until now, any one of those adjectives will be sufficient. That is, if it could be shown that conduct is severe or pervasive or objectively offensive, it could amount to sexual harassment. But under this Title IX regulations, all 3 would have to be present before you could hold that sexual harassment has occurred. The third one borders on criminality. Next slide, please. The third part of the definition borders on criminality. That is, on the basis of sex, there is sexual assault or dating violence, domestic violence, or stalking, as defined under various federal laws. Okay, I did mention that the definition here is important because they determine, or they drive the decision about what grievance procedure that should be used. Under state law, we know that typically the uniform complaint procedures are used to resolve a complaint of sexual harassment. Under Title IX, a separate procedure has now been prescribed by the Department of Education. Next slide, please. So, a school is required to do certain things when they have notice of sexual harassment allegations. So, the regulation specifies that when a school has actual knowledge of an allegation of sexual harassment, it must respond promptly in a manner that is not deliberately indifferent. Note the underlined words, a number of concepts here. There is a concept of actual knowledge. Okay, so actual knowledge under these regulations for an elementary or secondary school means that either the Title IX coordinator or any school official that has the authority to take corrective action or any employee of the school for that matter, if they receive any information or report of sexual harassment allegation, that knowledge is imputed to the school. That is what actual knowledge is for elementary and secondary schools. When that is so, that is when a school receives notice of sexual harassment, it is required to respond promptly in a manner that is not deliberately indifferent. Deliberate indifference is defined also. It means that the school must respond in a manner when all of the circumstances are considered, in a manner that is not unreasonable. I know there's a lot of negative implications there. That is not unreasonable, excuse me. So two things there. The school must respond promptly, and in light of known circumstances, that response must not be unreasonable. Okay, a number of things to note when it comes to this obligation that is triggered once a school receives a notice of sexual harassment. Number one is that duty exists whether a formal complaint is filed or not. So you cannot wait until a formal complaint is filed. Once notice is received, remember that notice to any employee of the school is taken as notice to the school. So employees perhaps need to be trained to ensure that the school receives the notice. Secondly, duty to respond involves treating complainant as well as respondent equitably. The feds, through these regulations, are very big on fairness to the respondent, which is a departure from what has been. So we're going to cover a lot of ground concerning that. Next slide, please. So when we talk about equity for the parties, they mean different things depending on whether you're talking about the complainant or you're talking about the respondent. So for a complainant, equitable treatment as part of the response once notice of sexual harassment is received would mean that the school must offer supportive measures to that complainant. In addition, the school or Title IX coordinator must consider the complainant's wishes, even in deciding on what supportive measures to employ. They must inform the complainant of the availability of those supportive measures, whether or not a formal complaint is filed. They must let the complainant know that the supportive measures are available to them, whether or not they go ahead to file a formal complaint or not. And then they must inform the complainant about the process for filing a formal complaint. For respondent, next slide, please. Equitable treatment means that the prescribed grievance process that the regulation calls for must be employed before disciplinary sanction or any other action that is not a supportive measure can be imposed on the respondent. Okay, so you cannot punish the respondent except you have completed what's the grievance process and it has found that the respondent is responsible for the conduct. Now, even with that, it does not mean that respondent may never be removed. In actual fact, the regulation allows for a respondent to be removed on an emergency basis. However, before any such removal, a step must be taken, and it is that an individualized safety and risk analysis must be done, and it must result in a determination that an immediate threat to the physical health or safety of a student or other individual justifies the removal of the respondent. Even when that is to be done, or when that is done, the respondent has to be given an opportunity to challenge the removal immediately following that removal. Next slide. Okay, so those are things that go to ensuring that both parties are treated equitably as part of the response to a sexual harassment allegation. So now we go into the grievance process. So here, the assumption is, or the presumption is, that a formal complaint's been filed. What's the process for ensuring that justice is done? Okay, there are basic elements that the regulation provides that the grievance process must include. So again, it talks about ensuring that the parties are treated equitably. It talks about an objective evaluation of all available evidence. There is the requirement for the Title IX coordinator, the investigator, decision maker, anyone involved in the process, to not have a conflict of interest against complainants or respondents generally, or even particularly against the complainant or respondent involved in any particular case or in the particular case or matter. Another requirement is that there is a presumption pretty much of innocence for the respondent, presumption that the respondent is not responsible for the alleged conduct until a determination regarding responsibility is made at the conclusion of the grievance process. There are more requirements. Next slide. Okay, the grievance process must contain prompt timeframes for conclusion of the process. It can't drag on forever. It must be designed such that it's prompt. They didn't provide specifics as to when the time, the deadline must be for concluding the grievance process. But as they've always said, it must be prompt. Again, as part of the grievance process, there must be a description of possible disciplinary sanctions or remedies that will follow determination regarding responsibility. If respondent is found responsible, what are the sanctions? What are the possible sanctions? What are the remedies for the complainant? They must be clearly stated. This is one of perhaps the most important requirements here. It's the standard of evidence for determining responsibility. The regulation requires that either a preponderance of the evidence standard is used, or clear and convincing evidence must be the standard that's used. A district or a school is allowed or is permitted to use either of this, but whichever one is adopted by that school or district for use, it must be used consistently. It must be used across the board for students as well as for employees. So you must note that. Also, The grievance process must include procedures and the permissible reasons that one may appeal a determination of responsibility, or a dismissal, if you will. Another one is description of the supportive measures that are available to either party must be clearly stated. And finally, whatever questions or evidence that may constitute or seek disclosure of legally privileged information may not be used, except when they are waived by the owner of that privilege. Next slide, please. Okay, so those are the basic elements of the grievance process. So but to begin the grievance process, as I said, there's a presumption that a formal complaint has been received. When that is the case, written notice then must be provided to all known parties. All known parties must receive written notice of a complaint. That written notice has a number of elements that must be in the notice. Number one is notice of the grievance process. You must inform everyone of what they need to do. The process must be clearly set out as to what each person or each participant in the process needs to do, when and how. This includes if there is any informal resolution process, it must be included. Informal resolution is not required, but if it is part of the process, it must be included in the grievance and the notice of grievance process. Another notice or part of that, the note of what must be contained in the notice, would be the allegation of sexual harassment itself. This must be provided in sufficient detail to the extent known at the time. It also the notice must provide or allow for the respondent sufficient time to prepare their response before any initial interview. And then there must be a statement in the notice that the respondent is presumed not responsible for the alleged conduct, and that determination as to responsibility will be made at the conclusion of the grievance process. Next slide, please. Okay, still on the notice requirements. The notice of allegations must inform the parties that they have a right to an advisor of their choice. That advisor may be an attorney or not, but whoever the advisor is, they would have the right to inspect and review evidence. And then the notice must also include information regarding anything in the schools or district's code of conduct that prohibits knowingly making false statements or providing false information in the grievance process. And finally, if during the investigation it is determined that additional allegations must be investigated, whether with respect to the complainant or to the respondent, where those allegations are not already part of the notice that's been given. Written notice of the additional allegations must be provided to all known parties. Next slide. Okay, so at this point, so this actually puts sort of a flag on the role of the Title IX coordinator, okay, because at the point of determining, whether sexual harassment under Title IX has potentially occurred or not, the Title IX coordinator has to decide whether, the process they are going to employ would be the Title IX procedure or whether it will be the Uniform Complete Procedures, the state process. So they are sort of the gatekeeper, okay, to determine which way a complaint should be handled. So that brings us to dismissal of the complaint. So there are times when a school is required, they are mandated to dismiss a formal complaint. 3 instances. The number one of which is when the conduct alleged, even if proved, would not constitute sexual harassment as defined under the Title IX regs. That is, they don't fall into one of the 3 definitions that we looked at the beginning. Number 2 is when the conduct alleged did not occur in the school's education program or activity. Okay, that is, it didn't occur at school or any location, event, or activity over which the school has substantial control over the context. So those would be outside of the purview of Title IX, and the regulations require that such a formal complaint be dismissed. And finally, when conduct alleged did not occur against a person in the United States. I don't envisage that this would have happened often since nobody is going anywhere these days, but a possible scenario might be, students are out of the country on a trip, say extracurricular activity out of the country, and something happens there that's not within the United States. It didn't happen to a person in the United States and will be dismissed as a formal complaint under Title IX. Next slide. Okay, there are also situations where the Title IX coordinator is permitted to dismiss a formal complaint. They are permitted but not required to dismiss a complaint. First would be if the complainant notifies them in writing of their wish to withdraw the formal complaint or an allegation. Second is if the respondent's enrollment or employment has ended. They no longer are in the school or work for the school, or if some circumstance prevents the gathering of evidence sufficient to reach a determination concerning the formal complaint or an allegation in it. Those, the Title IX coordinator can dismiss a formal complaint for. 2 notes here. Number 1, when dismissal occurs, whether because of a mandatory or discretionary reason, written notice of that dismissal must be provided to both parties at the same time, simultaneously. Secondly, note that dismissal does not mean that the school cannot still investigate under some other law or policy. So it only means that it's been dismissed as a Title IX complaint, but the school or district may still proceed against the respondent through the UCP if it qualifies as sexual harassment or bullying, under some other policy or state law. So note that. Moving on, next slide. Okay, so now we get into the investigation Again, a recurring theme is about equity, ensuring that equal opportunities are provided to both parties to present witnesses and evidence is one key part of this, and not restricting either party from discussing the allegations or gathering or presenting relevant evidence is another part of it. And then schools must recognize that the burden of proof is not the complainants. The burden of proof is not the respondents. It is the school's burden to bear. The school is required to bear the burden of proof and of gathering evidence to reach a determination. Next slide. Okay. Again, the parties must be provided same opportunities to have others present during the grievance proceeding. So if they have an advisor, it must be an advisor of their choice. That advisor may be an attorney, may not be an attorney. They are not required to have an attorney. And the school may not limit the choice of who they choose or the presence of such an advisor at any of the proceedings. However, the school has the authority to restrict the extent of participation of advisors. Where such restriction exists, it must be equally applied to both parties. Next slide, please. Okay. So these are just additional requirements, providing a party who is required to participate or who is invited to participate, information about how they may participate. That is dates, time, location, stuff like that. And also providing both parties and their advisors equal opportunity to review any evidence directly related to the allegations. Okay, now at this point, when you're getting ready to prepare the investigative report, evidence has been gathered, and all of that. Before a finding of fact is done by the investigator, at least 10 days, the parties must be, the investigative report must be sent to the parties at least 10 days before the investigative report is actually issued, so that those parties would have an opportunity to provide written response to the investigator concerning the facts that have been gathered. Next slide. Okay, the investigative report must be a fair summary of relevant evidence and must be sent to the parties and their advisors, if there is any. And again, must be sent to them at least 10 days before a hearing or if there is no hearing, or before the termination of responsibility is made. 10 days before, at least. You can have more, but not less than 10 days. Next slide. Now, we come to hearings. Hearings are not required for elementary and secondary schools, so we won't spend a lot of time on them. However, whether hearing occurs or not, before reaching a determination as to responsibility, each party must have an opportunity to submit written relevant questions that party wants asked of the other party or of a witness. And the responses or answers to those questions must be provided by the school or by the Title IX, by the investigator. And then the parties must be given an additional opportunity to ask limited follow-up questions before determination of responsibility is made. Next slide. Okay, and finally, under hearing, with or without a hearing, questions or evidence of complainant's sexual predisposition or prior sexual behavior are generally not relevant. There are a couple of exceptions, but we will not deal with them here. They're not really relevant. Okay, next slide. Determination as to responsibility. So under investigation, we dealt with findings of fact. Here, this is when there is a pronouncement. There is actually a conclusion that yes, respondent's conduct was actually sexual harassment, that they were responsible for it and such. Now, it must be in writing. And the writing must include the following. It must identify the allegations that potentially constitute sexual harassment as defined within the confines of Title IX regs. Okay, one of those three that we described at the beginning. Secondly, the procedural steps that have been taken from the receipt of the formal complaint to the determination regarding responsibility must be laid out. Thirdly, the findings of fact that support the determination must be laid out, and the conclusions regarding the application of the school's code of conduct to those facts must be well set out. Next slide. The written determination regarding responsibility must also include a statement of and the rationale for the result as to each allegation. The result, yes, respondent was responsible. Rationale, that is why you feel that they are responsible, must also be included. It must also include any disciplinary sanctions that will be imposed on the respondent, and whether remedies are designed to restore or preserve equal access, complainant's equal access to the education program or activity will be provided to the complainant. And finally, the written determination must include procedures and the permissible basis, the reasons that one might appeal the determination regarding responsibility. Next slide. We're coming close to the end, thankfully. So now we've been through the investigation. There's been a determination of responsibility. And remember, as we said, it must contain the process for filing an appeal if either party wants to. Also, an appeal may be filed if there's been a dismissal of a formal complaint. Okay. So the appeal would involve procedure, would have to be based on any one of the following reasons. One is you have to allege that there's been procedural irregularity that affects the outcome of the matter, or if there is some new evidence that was not available at the time determination regarding this responsibility was made, or dismissal, or the formal complaint was dismissed. Or if one wants to allege that there was conflict of interest or bias that involved the Title IX coordinator, the investigator, or the decision maker himself or herself. Next slide. Those are the reasons why one might appeal, or the basis for appeal. Okay, when there is an appeal, when a party files an appeal, notice must be provided to the other party that there is an appeal, and that notice must include the procedures that will be followed by both parties. The appeal has to be decided by someone who's not been involved in the process thus far. That is, the hearer of the appeal cannot be the Title IX coordinator, investigator, or the decision maker. The decision maker being the person that made the determination regarding responsibility. Cannot be either of any one of those. And then the school must ensure that the decision maker or the hearer of the appeal is trained as required under the regs. They have to know the law. They have to know, they have to be trained as to what might be relevant evidence or not. They have to be trained about electronic technologies that will be used if there is a hearing, stuff like that. Next slide, please. Okay, so, and again, both parties have to be given a reasonable, equal opportunity to submit written statements in support of or challenging the outcome of the matter. And then the appeal must conclude with a written decision describing the result of the appeal and the rationale for that result. And when that's done, the written decision must be provided to both parties simultaneously. I believe that concludes my part of the presentation, thankfully. Now I'd like to turn it over to Bob Twerk to share with you the policy revisions and moves that you would have to make. Thank you for listening.
Thank you, Bodhi. It's a lot of information that we're faced with now with these new regulations. Before I get started going, I just want to also give a quick thank you to Alex and Barbara for joining us, and Alex for moderating this session, as well as our other policy consultants who aren't in this webcast, Diane Green, Brianna Mullen, and Greg Francis, who all had a part in putting these policies together. In addition to that, we have a team of technicians who work tirelessly to make sure that these updates are posted, and that when you guys submit your updates, that they're also getting posted. So a big shout out to all of them for their work they put into these. So Bodhi covered a lot of material going over the legal requirements and the new Title IX regulations. I'm going to do my best to try and describe what that really means for you on the ground as school districts. You might have guessed by the title of this webinar, the first thing it means is you need to update some policies. CSBA has revised several policies and regulations, all just to address these Title IX changes. Those are listed on the screen here in this slide. In the interest of time and not getting into all the details, I won't cover them all, but I do want to make sure that we're highlighting a couple of them. So these policies also ended up getting published a little bit to you guys later than we normally would have liked to. That's because of this pending lawsuit that Bodhi has described. The timing of this is actually a part of the lawsuit. There were some 2,000 pages of regulations that came out in May, and districts and county offices and universities and colleges are expected to implement these new changes by August 14th, which is this Friday. So it's a very short turnaround period, not particularly realistic, and that's why it was one of the subjects of litigation and the pending injunction. If the injunction is granted, there are going to be some changes to these, and we'll be monitoring that and informing you if there is some kind of change, because some of the changes that we've listed in our updates will still apply. AB 543, for example, is a state law that made some requirements around posting of your Title IX regulations and sexual harassment policies in bathrooms, locker rooms, and websites. So there will still be some things that you need to revise, and we will follow up with you in the event that the injunction does get granted to let you know exactly what those are. So going to this list that we have on the screen there, the main ones that you need to be paying attention to are 5145.7 and 0.71, as well as 4119.11 and 0.12. Those are triple coded ones that apply. That's why there's all those slashes there. They apply to all segments of your employment and all of your staff. These spell out the processes and contain the bulk of the changes that Bodhi was describing. So I'm going to highlight just a couple of the major changes because these do create some potential pitfalls for school districts. The first one and the major difference that Bodhi indicated is that Title IX regulations now create a new procedural pathway for certain types of sexual harassment claims. As he pointed out, these are going to hinge on the definition of sexual harassment that's contained in Title IX. So if your complaint meets the federal definition of harassment, you have to follow the Title IX procedures. Those are spelled out in the new regulations that are listed on there, 5145.71 for students, 4119.12, etc. for staff. This requires a decision upfront because if the allegations don't fit the federal definition, you're still going to have to investigate them and deal with them under state law. So in the case of sexual harassment, as Bodhi pointed out, that's going to be your uniform complaint procedures in 1312.3. So your gatekeeper, the Title IX coordinator, has to be able to address those because the first step is for all complaints to go to the Title IX coordinator to make a determination as to what process you're going to go through. It may not be readily apparent at the front. So there may be a time in which you proceed down the federal path, decide that maybe it wasn't an and pervasive kind of allegation. So now you're going to dismiss and now you have to go back into the state world. So the Title IX role becomes critical to this, the Title IX coordinator. I think this is pretty well summarized in a part of 5145.7 that I'm just going to read to you guys. I normally wouldn't read from a policy, but I think that this really summarizes the key point here. All complaints of sexual harassment by and against students shall be investigated and resolved in accordance with law and district procedures. Title IX coordinator shall review the allegations to determine the applicable procedure for responding to the complaint. That's key. All complaints that meet the definition of sexual harassment under Title IX shall be investigated and resolved in accordance with AR 5145.71, Title IX sexual harassment complaint procedures. That's the new regulation that was just released. Other sexual harassment complaints shall be investigated and resolved pursuant to AR 1312.3, uniform complaint procedures. So again, Title IX has to make a big decision there. And this is Title IX coordinator, excuse me. This is key because oftentimes Title IX coordinators are just thought of as maybe a sports related thing. In California, we're looking at our Title IX sports equality, or maybe people don't take the role as seriously as they should. Especially with these new regulations, we need to make sure that we're getting in-depth quality training for the individuals placed in this role. It also becomes critically important because by their very nature, these complaints are against the district and they carry with them the possibility of district liability. So you want to make sure that you have the right people in the right positions who are properly trained to do this work. Now, for small school districts in particular, and especially in rural districts, this can pose some challenges, right? As Bodhi pointed out, you have to have segmented roles. You have a Title IX coordinator, you have a decision maker, you have a person hearing your appeals, and these can't necessarily be the same person. So that presents some unique challenges for districts that have fewer staff or that literally in some of the rural communities, your resources are few and far between in terms of distance. So what you end up having to do is look at alternatives. One possible solution to this is to hire an outside investigator to assist in this process. It is a cost. It's a cost that I'm sure nobody wants to bear at this point, but it's one of those situations where you have to think that a penny spent now could save you a pound later, or in the case of litigation, could save you hundreds of thousands of pounds. So it's a judgment call at the local level where you have to assess your resources and decide whether or not that's an investment that's worth it for the long-term benefit. So the second big pitfall that we look at with these new regulations is the removal of students. This is another thing that Bodhi touched on. And it creates some specific conflicts between state and federal law in the sense that Title IX does not allow discipline to take place until the grievance procedure has been followed. However, it does allow an emergency removal in certain circumstances. This might work at the collegiate level, but in K-12 education, removal by its definition is going to be a form of discipline. So these two areas don't really square with each other. And that presents a particular challenge for our districts here in California. So what is this going to mean for you? If we can move to the next slide. It means you're going to have to review and understand your regulations and policies. It means you're going to have to staff with appropriate people and provide a lot of training to cover these areas. And you're going to need to consult with your legal counsel whenever you have doubts about where you're going on this, because these kind of conflicts and these pitfalls and these alternate paths of dealing with complaints and procedural process really are ripe for potential problems and litigations for schools that may not be necessarily avoidable with this conflict between state and federal law. The federal laws preempt state laws, but they don't completely replace them. That's where we get that change in path of, if it meets the federal regulation definition, you follow that path. If it doesn't, you go back to the state path, but they still don't match up or square together. So there is definitely some potential for headaches for school districts here. So again, when you have questions, please consult with your legal counsel. Make sure you're getting proper training for your staff, because this is going to be a challenging area until it gets resolved, hopefully one way or another through these lawsuits that are pending. So with the next slide, please. We're going to turn to some of the other policies that we've updated recently. Don't have time to go through all of the updates that were in the policy packet, but I do want to touch on some of the special education related policies, as there were a handful of those that were part of this most recent update. So with the next slide. First one that underwent some revisions is Board Policy and Administrative Regulation 6159 on individualized education programs. It was impacted by a couple of different laws, notably SB 98, which requires the IEP to include a description of the means by which services are going to be provided under emergency conditions where instruction and services can't be provided to a student for more than 10 days. This is likely a fallout of what we've all experienced since March with the closures and the access issues to schools and providing services. Emergency conditions that apply are described in Education Code 46392. They're actually defined, not just described, but they include things like natural disasters, floods and fires, earthquakes, as well as epidemics like COVID-19 and what we're all facing now. And interestingly, strikes as well, strikes that prevent you providing services for 10 days need to be addressed in the IEP. So these IEP descriptions need to take into account public health orders, and they need to include special education and related services, supplementary aids, transition services, and extended school year services. So you're going to need to go back and look at IEPs for possible adjustments in response to SB 98. Next slide, please. 6159 was also impacted by AB 947, which requires evaluations for students, specifically students who are blind or have low vision or are visually impaired. And in the interest of time, because I know we've got a couple other things to cover, I'm going to go on to the next slide. And if you guys have questions about any of these specific laws or policies, please go ahead and send them through the chat or contact us directly at the end, and we can make sure we follow up with those. But I wanted to touch on AB 605, which also touches on 6159, because this requires devices to be provided. And as we all know, with COVID-19, we're all dealing with different devices of different types, but specifically here, this is dealing with devices as defined in 20 USC 1401. which are any piece of equipment or product or system that is used to increase, maintain, or improve functional capabilities of a student with a disability. In the world of distance and remote learning, that definition becomes a little bit more broad. And so it's important to note that this has been included in 6159 and is now part of the IEPs. And you need to also make sure you're continuing to provide access to these devices for at least 2 months after the student has left the district. Next slide. So this one deals with procedural safeguards and complaints for special education. These changes are the result of new state regulations, and these regulations require that complaints alleging violations of federal or state laws or regulations related to the provision of FAPE need to be submitted to the California Department of Education rather than being processed through the Uniform Complaint Procedure. So that's a departure in a normal practice. So now these complaints need to go to CDE instead of being processed through your UCP 1312.3. The new process for doing this is spelled out and defined in AR 6159.1. So you're going to want to review those to see that new process and be aware of that change so that you make sure you're properly referring these to CDE. Also, the complaints need to be sent to the Office of Administrative Hearings, and they generally should be filed within 2 years of the date that the party knew or had reason to know of the facts. However, there's an exception to that. If it's found that the district misrepresented that they had solved the problem or that they withheld any required information from the parent or guardian, it's going to toll that 2-year statute of limitations and allow the claims to be brought at a later date. Next slide. So this was also affected by AB 1172, which impacts the next slides as well. These deal with non-public, non-secretarian schools and agencies and their relationship with the district. AB 1172 requires districts to verify that proper staffing and training is being used at these NPSAs, and it also changes some contract requirements. It's important to note that the district needs to pay the NPSA their full amount of tuition or fees as applicable for the students with disabilities that are being served by the NPSAs, because those students are deemed to be enrolled in public schools for state apportionment purposes. So you are required to pay those full fees. Next slide. There are also some contractual changes that came out of AB 1172 that are going to impact your district, as well as some visitation criteria that are summarized in this slide. One of the main changes is the contracts can be terminated for cause within a 20-day notice, and that your required annual visits, you either have to do a visit, the first time a student is placed with an NPSA, as well as an annual visit. And the reports and findings from those visits have to be reported out to the CDE using their published criteria. And all of these details are contained in Administrative Regulation 6159.2. So with that, sorry, I buzzed through a lot of information pretty quickly, but I'm going to turn this over to Barbara, who's going to talk to you a little bit about some recent changes regarding infectious diseases. Barbara?
Thank you, Bob. So I'm Barbara, and I'm going to speak to 514.22 infectious diseases. So next slide, please. So why did we update board policy and administrative regulation 514.22? So just a little bit of background. Our current circumstances, as we all know, we're in a time of COVID-19. And I think many of you are aware that CSBA has a sample policy dealing with the COVID situation. It's 0470, the COVID-19 mitigation plan. And this policy is inherently temporary. So we thought it was really important to put some of the ideals and concepts and materials that we've learned from COVID into a more long-term place. So that home is now in 514.22. And there was also some new law which impacts this policy. So next slide, please. So we'll first talk about the new law, which is AB 262. And this new law adds Health and Safety Code 120175.5, and it puts requirements on both local health officers and on our districts. So for local health officers, they're required to promptly notify and update districts during an outbreak of a communicable disease or upon the imminent and proximate threat of a communicable disease outbreak or epidemic that threatens the public's health if, in the opinion of the local health officer, action or inaction on the part of the district might affect the outbreak response efforts. So in other words, if there is an outbreak or a threat of an outbreak and districts can affect the outbreak efforts and help to minimize or on the opposite, if they can make it worse, then we need to be a part of solving the solution. So we will be notified by the local health officers if that were to occur. The other requirement is to make any relevant information available to districts, including the locations of concentrations of cases, the number of residents affected, and the measure that districts should take to assist with outbreak response efforts. So we will also be informed of, and have enough knowledge of what's going on in our area to hopefully help deal with the problem effectively. Districts are also required to do certain things under this bill or this new law, which is one is to take any action that the health officer deems necessary to control the spread of the disease. So I think we're all pretty comfortable with this at this point, similar to what we have to do during COVID. If our local health officers have an order put out, we need to comply with that order. And another requirement is to comply with all applicable state and federal privacy laws as to information received from local health officers in this regard. So the privacy laws that exist, both state and federal, exist for the information we receive from our local health officers. So we always have to be sensitive to privacy information and make sure we follow the laws accordingly. Next slide, please. When developing and updating emergency and disaster preparedness plans, it is important to be aware of a few things. One is to ensure that all measures to limit the spread of infectious diseases are non-discriminatory and that equity is promoted. There are some components that are good to include, which are preventative measures, mitigation, education, communication, and training. And I think from COVID, we really learned how important mitigation is, especially in situations where risks cannot be eliminated. So in order to attempt to return to normal school operations, or as normal as we can be, we need to provide many mitigation efforts to hopefully be able to return to a safe way of educating in person. The other two factors I think that we really were highlighted with COVID is communication and training for all of our stakeholders, for parents, guardians, students, and staff. Because when something like this occurs, it tends to be new and new knowledge and new information that we need to learn about, as well as training to learn how to accommodate and to live safely with the new circumstances that we find ourselves in. And again, it's always important to regularly review our resources and confer with our local health experts because they really have the knowledge in terms of the health issue itself. Next slide, please. So the policy also includes universal precautions, protocols to follow for students with infectious diseases, and we did clarify regarding allowable exclusions that they apply only to on-campus instruction. So we have learned, as we all know, that even when all students have to be excluded, we still have a responsibility to educate virtually or distance learning. So the exclusion can apply to only on-campus instruction. And also that we are required to inform our local health officials of potential outbreaks in our areas and in our schools. Next slide, please. So we also did a little work to the administrative regulation. The biggest change was probably that we did put a portion in about components of a prevention and mitigation plan. And many of this was taken from the COVID mitigation plan, but it was done in a much more generalized format for a much more universal application. So I'm just going to run through the list quickly. I'm sure many of you are very aware of these because we're dealing with these on a daily basis right now. But they are communication, campus closures, alternative instruction when necessary, including provision of instruction to students with disabilities, English learners, foster and homeless youth, guidelines regarding preventative measures such as social distancing, personal protective equipment, and temperature checks, acquisition and provision of personal protective equipment, procedures for the cancellation and or alteration of extracurricular activities and field trips, transportation, information and training on effective hygiene practices, continuation of free and reduced price meal services, protecting high-risk students, school climate and emotional well-being of students, cleaning and sanitization, visitors and outside groups, and staff training. The AR also includes universal precautions in the classroom, and we did update some notes about laboratory safety and universal precautions that we hope help districts in the implementation of the policy, especially in the laboratories. Next slide, please. So there's two very valuable resources that you might want to look at when attaining a better understanding of the policy and perhaps when doing your own planning in your districts. One is from the U.S. Department of Health and Human Services, the School District K-12 Pandemic Influenza Planning Checklist. And this was done, I believe, into H1N1, and it is a very, very thorough, inclusive list that for the most part, well, I guess we don't know what will bring us, but at least up till now, it looks like it really could serve as a universal checklist for different situations. And also from the California Department of Education, there is a science safety handbook, which is very good, especially in terms of laboratory safety and universal precautions. And next slide, please. So Alex, back to you, I believe, to next go on to the questions and answer session. And thank you for listening.
Thank you, Barbara. Thank you to all of our presenters. At this time, we will take questions from the audience. Please submit your questions as you have been through the questions on the GoToWebinar dashboard. We had a few submitted in advance, so I'm going to start with those. To our panelists, are there any differences for county offices of education for these policies?
So I can jump in and take that one. The Title IX, I'm assuming these are the Title IX policies that we're talking about. The Title IX regulations do also apply to county employees and students. And so that's all going to be part of it. There are going to be some policy differences, at least in terms of the sample policies we're releasing. There'll be county policies coming out hopefully the end of this week because county boards don't address employees. There won't be a 4,000 series of employee policies to deal with, but there will be one dealing with students. But in terms of the process and the procedures, those all still apply to the counties as equally as they do to districts.
Thank you. Next question up is there a board policy on digital signatures? I think that I was actually going to take this one. No, there isn't currently because there are so many different places a signature will show up. You have contracts that the superintendent may sign, you have employment contracts, you have services contracts, you have things your parents sign. If you had like a specific thing you're looking to see if it gets signed, if you could please email us at policy@csba.org. I can get you a more complete answer since it would be a very specific question of what you needed signed digitally.
Yeah, I would add to that, the Secretary of State did promulgate some regulations on this, but Government Code 16.5 spells out the requirements for a digital signature, and they are valid signatures so long as you're following the 5 steps that are outlined in that Government Code section.
Thanks. Could all members be provided with the mandate list of updated board policies?
So it is available to Gamut subscribers. If you want to contact us, we don't generally send it out with our updates because when that happened a few years ago in the past, there was some confusion and people tried to adopt the list as a policy itself. And so to cut down on that confusion, we do not send it out with the updates. It is available on Gamut when you log in. There's a list on the right on the new Gamut where you can access those mandated policies. Or you can always email one of our consultants at policy@csba.org and they can provide that to you.
Next question. It will take some time to get the policies updated. What happens if the policies are not changed by August 14th?
Bode, do you want to take that one? It's a good question.
Well, yes, I'd like to take that. As with any other policy, the regulators expect you to do your best to ensure that you are in compliance as quickly as can be. It's also recognized that this particular set of policies involve regulations that are the subject of litigation, and that has delayed things. And above all, COVID-19 and its effect on the entire society would have to be factored in. So I expect that they probably would not strictly enforce its implementation until you've had some time to adopt the policies that you need to be able to to operate based on the regulations.
Yeah, and I agree. And the August 14th deadline, again, that's part of the reason there is this lawsuit and the injunction pending. That was one aspect of it. It's a tight turnaround time from mid-May to mid-August to digest 2,000 pages of updates and changes and implement them is not realistic. So that's part of why these injunctions were sought. But you can, as long as you have these in place before you're faced with some of these procedures so that you're following the right process, I think you're going to be okay. So when you're adopting these policies, you're going to want to get it done pretty quickly and probably consider foregoing the traditional first reading, second reading, and agendizing it as a first reading and action item so you can get them adopted quickly.
Thanks, Bob. What legislative bill were these changes in? What becomes effective on August 10th?
I'm assuming, again, these are Title 9 questions. The others, there's quite a few bills that were addressed. Bodie's better at the citations than me. I'll turn it over to him. He's got a much better mind for that than I do.
Well, I do know for Title 9, it's not a piece of legislation were developed by the U.S. Department of Education, and so they are in Title 34 of the Code of Federal Regulations, Part 106.
Thanks, Bodie.
And for the other ones, you can always check the guide sheet, and they're listed in there what the bills and regulations are. That's also available on the GAMA homepage.
Thank you. What training opportunities are available for board members and administration to learn the new GAMUT online system?
That's another good question. So we, the best way to do that is to contact our training and support team at gamut@csba.org. They can schedule individual training for you, or they can get you set up with some webinars and pre-recorded trainings that they've been working on. So again, gamut@csba.org, and they can get you set up with any training needs that you need for the new system.
Thank you. Will CSBA have a sample Title IX policy available to all members?
To all members who subscribe to our policy services, yes, absolutely. So all the policies that we provide, with very limited exception, are available to GAMUT subscribers, which is, I believe, 97% or so of the membership. If you need a GAMUT subscription, you can always contact either policy@csba.org or gamut@csba.org, and they can help you out with that.
Okay. And this was also kind of covered before, but will you be going over how the new policy update works in GAMUT?
Our friends at gamut@csba.org will help you out with that, but yes.
Thank you. Okay, and then that's all the pre-sent ones. We have a question probably for Bodie. What if you are at a school district with a principal superintendent and would traditionally hold the roles of investigator, coordinator, and decision maker? Can the governing school board be the decision maker?
That's a good question. So the problem with that is that that governing board will still be required to say this procedure or this process goes through the entire thing, and then you determine that a student was responsible for sexual harassment based on Title IX. Remember that the school board is the only body that can expel. And so having the same body be the decider or decision maker, as well as that same body that will be charged with the responsibility to expel the student if need be, if it's that bad, doesn't seem like would accord with the intent of the regulation as they have it, especially when they specifically set it out such that the Title IX reg must not be the investigator, or even right. Well, maybe they can be the investigator, but they must not be the decision maker. And the decision maker cannot be the person in charge of the appeal. And so so this is one of the critical points, one of the biggest problems that we've seen with this process. It didn't take into account that really so many schools or so many districts are small districts. They are limited in terms of financial as well as human resources. And they essentially use a process that should be for higher ed and imposed it on elementary and secondary education, which doesn't make a whole lot of sense.
Yeah, it could be technically possible maybe, but it's certainly not a best practice. And you also have to remember that training component, right? Especially on these investigations and decision making. Unless you're going to provide a whole bunch of training for your entire board to do this properly, it's just probably not a best practice.
Thank you. There's a question on when these sample policies would be sent out. They were sent out July 31st. If you did not receive them, please email me at policy@csba.org and we'll get those for you. Another Title IX question. Under the new regulations, school administrators must not speak to respondents before a notice of allegations is sent to respondent. If the Title IX coordinator concludes that a matter is not Title IX sexual harassment and is sexual harassment under state law, then administrators could interview a respondent without notice of allegations being sent? Question mark? Thank you.
Okay, so there's a point where if it's not sexual harassment under Title IX, then the district must dismiss the Title IX end of stuff. They cannot continue with Title IX. They're done with Title IX. But if the school or the Title IX coordinator believes that there is enough there to go on the state route to investigate the allegation as sexual harassment under state law, that process applies. So if one is allowed to essentially contact the respondent before the notice of allegation under that will be okay. But I doubt that that will not be challenged by the feds, because there's a lot of supposition here because we don't know for a fact how it's going to play out. That's part of what the problem is. So I would say it's better to use the more robust process. So if Title IX says you cannot contact them until the notice of allegation has been provided to them, even if they end up not being Title IX, okay, I would follow the same requirement, the same rule before I applied the state procedure.
Yeah, I think that's the smart way to do it. I mean, procedurally, I mean, just timing wise, right? You're talking about the notice of the allegations. So practically speaking, once you've started down the federal process, if you decide that it gets kicked back over to the state and you're looking at UCP, it does have an investigation component where you're interviewing people, but at that point, you're so far down the road, the notice has been provided. Where this might come into play is if you're initially going down the state route instead of the federal route, then maybe you haven't received that notice, but at that point, you've already made the wrong choice, because you have to follow the federal procedures if they apply. So that's where it goes to the Title IX coordinator to make that judgment call up.
Yeah. And that point is critical. If I may say something else there, when you do that and you then find out that you should have proceeded under the federal procedure, then because you didn't, it will be almost impossible to then impose sanction on that respondent, because the feds are going to say you didn't follow the federal procedure. So as a safe harbor, it's as Bob said, it is better to start with the federal, because that's the more robust one. And if then you decide that it's not, it will not nullify going under the state procedure. But the other, if you do it on the flip, in reverse, then you might actually have created a lot of problem.
Okay, we have time for like 2 more questions. The first one is kind of a combination of what actions do you suggest boards take if an injunction is issued against Title IX, and when do you anticipate a ruling, if any, to come down?
Great question. I have no idea when the ruling is going to come down. I actually was just checking while Bodie was speaking at the beginning of this webcast. There's nothing, so the final decision that we're waiting on is the case that's been filed in the District of Columbia. And that's the one that the state of California is also involved in. They haven't had any filings since Monday. These are supposed to be implemented by the 14th, so you would think sometime before Friday they're going to rule on the injunction, because otherwise it kind of becomes moot. If they do enjoin these, we'll be sending out some sort of communication to let you guys know which policy revisions we sent out no longer apply. But like I said, there's some specifically around posting requirements that still need to be implemented. So we'll be making sure we provide those updates if necessary. But as Bodie indicated, 2 courts have already said the injunction is denied. So it wouldn't be surprising to hear that from DC as well.
Okay. We're going to ask one last question. There are a few other questions out there. If we don't get to it, or if you still have it, please email at policy@csba.org and we'll get you that answer. But the last question, can you suggest any providers who can provide training to Title IX coordinators?
I knew this question was going to come. I don't have the answer. I know CDE has some resources. The Department of Education, under the previous regulations, put out some guidance documents. Those are no longer going to be applicable. But we can follow up with you. If you want to send that question in directly, we can follow up with you on that and see what kind of resources we can find. Unless, Barbara, I know you did a lot of work on this. If you came across anything in your research that might be useful.
No, not in terms of resources for training that I'm aware of. I can research it further though.
Thank you, Barbara. Okay, thank you everyone for your questions. If you have any additional questions, please email our team at policy@csba.org. And for questions on like training and gamut or like that specific stuff, you can also email directly to gamut@csba.org. Is your board subscribed to CSBA Gamut? Gamut Policy and Policy Plus provide a streamlined process to view and research CSBA sample policies and manage your board policies. Gamut Meetings, paperless board meeting management software, makes meeting preparation easy for your staff. For more information regarding pricing, subscriptions, or to request a free demo, send us an email at gamut@csba.org today. CSBA's Online Learning Center offers you access to a wealth of resources to help you on your journey of learning. Start learning today from the comfort of your own home, office, or wherever you have access to the internet. Best of all, you get 12 months of access for only $300 per subscriber. CSBA is dedicated to providing up-to-date resources to school board members during the COVID-19 crisis. To view information on guidance for COVID-19, please go to our webpage at csba.org/coronavirus. If you are interested in attending future CSBA webinars, please go to our website at csba.org/webinars to register for upcoming webinars. Many thanks to our presenters, Bob, Bodie, and Barbara. And I just wanted to thank you all for joining us today, especially those who contributed questions. With that, thank you, and we will see you at our